Good morning everyone and welcome to this What's Next webinar. I'm Belinda Wheatley, HR Strategist at What's Next, and I'm going to be your host today for this webinar. So why are you all listening this morning? Well, I'm guessing that's because you are concerned about the potential risks of bullying in your workplace. You want to stay up to date with the new bullying legislation, or you want to be proactive and make sure that your systems and frameworks, that you're compliant with your systems and frameworks and that you're doing everything you can to reduce your risks. So this will be time well spent for you this morning. I want to commend you all on your proactive approach and taking the time to listen to this webinar. By now you may be aware that the Fair Work Amendment Bill has passed by Parliament. This includes new anti-bullying measures which are due to come into effect on the 1st of January 2014. This legislation will allow a worker to make an application directly to the Fair Work Commission if they believe they've been bullied in the workplace. So in this webinar, I'll discuss the impacts of these changes potentially on your business and how you can prevent from becoming a test case in 2014. There's been quite a lot of talk in media around the fact that this new legislation means that a worker is not required to raise an issue of bullying internally before they apply to the Fair Work Commission. So obviously there's been a lot of discussion around that, and I'll talk about that further today. We are anticipating, and everyone's anticipating, that we will see a spike very early on in the piece in applications and in the number of claims. It's expected that a number of these will be unsubstantiated claims from employees. And what I mean by that is it may be a worker who believes that there's a case of bullying, but it is in fact reasonable management and reasonable management action, and we'll talk further about that as well. I was very fortunate earlier this week to be at a dinner with the Honourable Justice Ian Ross. For those of you who don't know Justice Ross, he's the current President of the Fair Work Commission. So I'll take the opportunity throughout the webinar today to actually share with you some of his comments from earlier this week. So what are we going to cover? The new anti-bullying laws, which I've touched on. We'll talk about the definition of bullying. Also, who can apply to the Fair Work Commission and what is defined as a worker. Then what can the Fair Work Commission do after an application's been received? How will this impact your business? What you can do to reduce your risks and be proactive. What What's Next are doing for their clients and what we can do to assist you if need be. Then I'll summarise and just with the key messages and points I would like you to take away from today, and also time permitting go through and answer and respond to any questions you may have. So there's a lot to cover. I will go through the slides fairly quickly and so that I can sort of give you as much insight and information as possible. You will be welcome to contact me on the back of today's webinar if you have any questions as well. So let's get underway. Bullying is defined as repeated unreasonable behaviour towards a worker that creates a risk to health and safety. This does exclude reasonable management action carried out in a reasonable manner. So reasonable is one of those things, how long is a piece of string? Quite often when you have this discussion, people then ask, well, who decides what is reasonable management action? And the answer to that will be the Fair Work Commission will decide on an individual case-by-case matter of what is reasonable or has action been reasonable. So bullying is not legitimate and reasonable management action and genuine business decisions, provided these are conducted in a reasonable way. Furthermore, bullying, it's not bullying for a manager to counsel an employee about their performance or have discussions. Performance management and providing role clarity and giving clear expectations to employees and feedback on those expectations and whether they're being met is a necessary part of leadership and of good management. So we definitely encourage our clients, and I encourage all of you to continue having performance management discussions, and don't be afraid of that, but it's how it's conducted. The really interesting point, and one of the things that Justice Ross pointed out the other night, is even though it's repeated unreasonable behaviour, that behaviour doesn't need to be the same behaviour over and over. And what I mean by that is it may be verbal behaviour, then it may be actions, or it may be emails. So it can be a range of different behaviours towards the worker over a period of time, but not necessarily the same behaviour. I'll talk further on about who is defined as a worker, because that's a really, really important point, and also talk further about the risk to health and safety. So impacts on you as an employer can or may include reduced efficiencies and reduced productivity, and therefore we all know that that correlates with a reduced profitability. Poor morale, erosion of staff loyalty and commitment, normally that results in high turnover. An unsafe work environment, increased costs associated with recruitment and training. Obviously, if a business is experiencing high turnover, there's then the replacement costs and also the onboarding and the training of that new staff, not to mention the impact that that has on co-workers who are picking up the workload, who are assisting with the training, and also losing some of their colleagues. There's potential legal costs as a result of employee claims, adverse publicity and poor public image. We hear so much these days around brand and the importance of brand, and with social media being such a big part of today's workplaces, any publicity and certainly any test cases come 2014 are going to be in the media and going to be talked about. So definitely something you want to avoid for a range of reasons. The hidden costs associated with bullying is really hard to measure and really hard to put a dollar value on. But we know the companies that have a really positive culture where bullying is not accepted, or where reasonable performance management is part of the culture, we do know that that results in certainly better productivity and lower turnover, things like that. Toxic cultures, it may sound like common sense, but certainly toxic cultures do not result in higher performance, productivity, or higher profits, which I don't know many people who are in business and not hoping for higher productivity or profits. Impacts on the employees. There are a lot of impacts and a lot of really detrimental impacts to employees who are bullied in the workplace. We hear a lot about bullying in the schoolyard, and that gets probably more publicity than bullying in the workplace, but it's certainly a big deal and something that carries on into our adult lives in our workplaces. So the impacts can be things like stress, anxiety, sleep disturbance, panic attacks, incapacity to work, reduced performance and loss of self-confidence rather, depression, reduced quality of home and family life, and in really extreme cases, suicide. So workplace bullying definitely has a broader impact than just what goes on in the workplace. Some of you may have heard of Brodie's Law. There was a young female waitress called Brodie Panlock who committed suicide after experiencing persistent vicious bullying by her co-workers. It was a case where, and I won't go into too much detail, but the employer was aware that the bullying was taking place and made comments such as, guys, take it outside. So they're aware of it, they did nothing about it, and unfortunately it was a very, very sad case where that resulted in the employee committing suicide. There was no criminal charges laid in that case. However, in 2011, the Victorian Crimes Act was amended to ensure that serious bullying could be punishable with up to 10 years imprisonment. So that is a Victorian case, and that Queensland hasn't followed suit to date, so it's going to be a matter of watch this space, but certainly that seems to be, you know, the way of the future. So why have the changes in bullying legislation come about? Well, currently, bullying that does not cause an injury or illness severe enough to involve unfair discrimination or constitute sexual harassment is not dealt with under any legislation. The new laws are designed to encourage prevention and bring about a very swift resolution. One of the things that Justice Ross commented on the other night, and he reiterated it time and time again, is these laws are about prevention and ensuring that workplaces are doing all they can to prevent this. There's not a quick fix, and certainly that's the place that the Fair Work Commission will be coming from, is how do we ensure that this doesn't continue to happen. So you'll hear me talk about prevention a lot this morning. Currently there's an estimated $36 billion in lost productivity as a result of bullying in Australian workplaces. I mean, that's a massive figure, and hence why some changes need to be made. So it's important to familiarise yourself with the legislation. You need to do that to protect your business and ensure that you're compliant and mitigating the risk. So I've already said that one of the biggest issues for employers is that employees who feel they've been bullied at work will be able to apply directly to the Fair Work Commission. The first that an employer may know about this is when they receive a notification from the Commission. And I will talk to you later about the best way to manage this and ensure this doesn't happen internally. But if an application is received by the Fair Work Commission, they're required to deal with all complaints within 14 days. So that's a really rapid response time, and they want swift resolutions in these cases so that it's not an ongoing situation. An important point is that it's about an employment relationship because it's about preventing ongoing bullying. So if someone has resigned, then they're obviously no longer in an ongoing employment relationship. So that's just something to note. For someone to be able to apply to the Fair Work Commission, put in an application to stop bullying, they must be a worker. And I said earlier I'd talk about the definition of a worker. So a worker is an individual who works for a constitutionally covered business in any capacity. So by any capacity I mean they could be an employee, they could be a contractor, they could be an apprentice, they could be on work experience, and they could be a volunteer. So it's very, very broad and has far-reaching ramifications for employers who have one or all of those. It does not cover members of the Defence Force, which is interesting. The worker must have a reasonable belief that they are currently being bullied and that it's ongoing. And I talked about the fact that they must be in a current employment relationship with the same employer. The interesting thing to point out is there's no income limit for applicants for bullying. With things like unfair dismissal, there is a income limit of currently about $129,300. So if you're over that, if you earn over that, then you're outside the unfair dismissal. With bullying, that's not the case. So it's very it's open to employees that other legislative avenues aren't. So what can or what will the Fair Work Commission do? Well, that's going to be a little bit of a matter of wait and see. But the Fair Work will make orders if they're satisfied that there's a risk of continued bullying. So one of the first things they're going to assess is there actually ongoing bullying occurring? They cannot make compensation or reinstatement orders. So it's not about putting a monetary amount to this, and I will talk about that further. However, orders can be made to employers to stop specific behaviour, to monitor behaviour, to review or comply with workplace bullying policies if they're in place, to provide information to workers, or to provide support, training and a review of their workplace bullying. A breach of an order made by the Fair Work Commission exposes employers to civil charges. Justice Ross pointed out that the Fair Work Commission will not encourage monetary settlements. The reason for that is they want to prevent ongoing bullying. So a monetary payout or go away money, as we quite often call it or see, does not prevent ongoing behaviour. It's a really reactive way to handle these situations, and it's not encouraged by the Fair Work Commission and won't be well perceived. So what impact will all of this have? There's definitely concerns that there'll be an increase in psychological claims by employees. The Fair Work Commission have the capacity to decide whether an action is reasonable and therefore have the power to interfere with your management prerogative to run your business if it's not seen as reasonable practices. The Fair Work Commission can make orders if it considers appropriate, such as reviewing your policies and procedures or conducting refresher training. The Fair Work Commission really want employers to own these resolutions. They will assist by stepping employers through to a solution, but employers really have to own this. So what will put you at risk, or what may be putting you at risk coming into this new legislation? Insufficient, or in some cases non-existent, HR documentation and processes. So if you don't have basic HR documentation such as clear current role descriptions, employment contracts, workplace behaviour policies and also procedures. But a policy and a procedure is not worth the paper it's written on if you haven't communicated that effectively to your workforce and conducted training and also conducted refresher training. So you need to have formal systems, formal processes that assist your employees in knowing what to do and what steps to take internally if they feel bullying is occurring. The process also has to have steps in how employees will respond to those claims in a really efficient manner and safe return to work procedures. If you're falling down in any of these areas, then it's something that we highly recommend that you get onto as quickly as possible. It's about the culture that you want to create in the workplace. You need to encourage a positive, respectful culture where there's no tolerance to bullying. People know it is what's expected of them and what is inappropriate workplace behaviour. If people step outside that, whether they're in a leadership position or no matter what position they're in, then action needs to be taken to show that it's not all talk. You actually do live by your policies and procedures. The Swan vs Monash Law Book Cooperative. Some of you I know would have heard my podcast a few months ago regarding bullying. This is a case I talked about in quite a bit of detail, and the reason being it has quite a significant financial outcome of nearly $600,000 in a payout. So the case was an employee was a victim of prolonged bullying in the workplace, and when I say prolonged, it went on for about 5 years. The employee continues to suffer severe psychiatric illness as a result of this ongoing bullying. There was detailed evidence in this case of abusive language. There was a book throwing incident where the employee actually had a book thrown at them. There was demeaning conduct over this 5-year period. A lot of comments about, and this isn't the exact wording, but you're stupid, why can't you do that sort of thing. When the court looked at this case, they considered things like the fact that there was no clear current role descriptions or role clarity. There wasn't employment contracts or workplace behaviour policies to enforce expected behaviour. There was no policy or procedure in place on what steps to take. No training had been conducted, so there was just no formal systems and no avenue for the employee to seek assistance. The employee did in fact take this to the board, and the board verbally said that they would take some action, update their policies, do some training, but then failed to come good on any of that. So they were well aware that this was going on, and obviously that didn't go well, didn't go in their favour, and hence a significant payout of close to $600,000. The podcast where I talked about that and in more detail is available on our website if you're interested in hearing more about that case. So what can you do to reduce your risk? Firstly, assess risks that may be present in the business. Sometimes, sadly, employers don't know what they don't know, and there may be a situation of bullying or the culture, it may be rife in the organisation. We conduct for some of our clients employee culture surveys. That can be done face-to-face or online, depending on the size of the organisation. The culture and feel and the temperature of the organisation is only one of the reasons that we do those surveys, but it certainly allows us to get a feel for what's going on and what is perceived as appropriate behaviour in that workplace. We recommend you provide rock-solid policies and procedures to employees on bullying, but not only have policies and procedures, but communicate these, train the workforce, have them in your onboarding and induction processes, conduct refresher training, instill confidence in your employees by following policies and procedures. Don't just talk the talk. Inform your decision makers, your people managers, or your leaders of your organisations about these changes in legislation and what it means and what the risks are. Your leadership team need to be leading by example. Bullying prevention needs to be a core part of your business. It needs to be part of the culture and something that's taken seriously in the unfortunate case of a complaint. So, I'm not sure if you're aware, but more than 1 in 5 people are bullied at work, and 1 in 3 employees are affected in some way by workplace bullying. That can be that they see workplace bullying, so they may not necessarily be the one being bullied, but they may be a witness to it, which can also have quite a detrimental impact on an employee. Workplace bullying is costing Australian businesses, as I mentioned, about $36 billion per year. To prevent your business being part of this statistic, we recommend a bullying prevention package is what we call it. But we actually have a package that we've implemented with our clients and that we can assist you with if you don't have the internal resources or capability. What we recommend is bullying and sexual harassment and anti-discrimination policies. Social media policy, and that's a whole other topic on its own, but highly recommend a social media policy. I mentioned earlier about email being a form of bullying. You hear a lot about cyberbullying, particularly for school age. Cyberbullying is also becoming more and more of an issue for employers. We have a lot of people who work remotely, work from home, and this was one of the things that we discussed with Justice Ross the other evening, is how are we going to define the workplace? That is, if someone's working from home, receiving emails, or something happens online, be it Facebook, or is that then going to be a case, if that's ongoing, is that going to be a case of bullying? And certainly it'll be a case-by-case basis, but that looks to be, it certainly will be included in ongoing bullying behaviour. So getting off track a little bit there, but I would also highly recommend looking at a social media policy so people know what is expected when they're online representing the company. So investigation and grievance and performance management procedures are all necessary if you don't have them. If you do have them, look at updating them or look at conducting refresher training early in the new year. Internal procedures need to ensure that the first step is to report inappropriate behaviour internally. This is something that the Fair Work Commission will look at. If you have policies and procedures in your workplace that are current, that have been communicated, and you've trained your employees in these, and the employee then does not follow your internal policies and procedures, the Fair Work Commission will take that into consideration, and it will be viewed favourably that you have those things in place. This is not a set and forget process. It needs to be monitored. It's not a difficult process by any means, but it's not a, okay, we put that in place 3 years ago, done. So I keep harping on refresher training, but as well as having it in your induction process and just booking in that annual refresher training. And training itself cannot be a tick and flick. It can't be, okay, we've done that, everyone tick a form. It needs to ensure that people have understood what's expected of them. Actually, just going back, one of the other things that I mentioned regarding the workplace, another podcast that I did was around from a health and safety perspective, you know, and we're going to see, I think, some more interesting cases around, we've all heard about the employee that was working from home who slipped in their socks, and, you know, is that covered under workplace health and safety? You know, what part of your house is in fact your workplace when you work from home? And it's interesting that that definition or that now will flow across into workplace bullying. So I think there'll be some interesting cases about that in the new year. So I've already touched on some of this. Fair Work Commission will have the capacity to decide whether an action is reasonable, and therefore have the power to interfere with management's prerogative to run their business if they feel that has not been reasonable management action. So I've harped on a fair bit today about the risks, but insufficient or non-existent policies and procedures, or no training in these policies and procedures, will put you at risk. So take action, if you haven't already, to prevent bullying in your workplace and have a culture where it's not acceptable. If something does happen, resolve it quickly. Encourage people to take action internally and to notify you if anything is going on. If you walk out of today's webinar and any of this is going on in your workplace, you may have some inappropriate workplace behaviour occurring, and I would recommend that you give me a call or certainly get onto it internally. So I have left some time now to answer some questions, but if there's some things that you'd like to discuss offline, here's my email address, and our contact details are on the bottom of the screen there. I will be running another webinar in January and also in February. By February next year, I'm expecting that there'll be some individual cases, and we'll start to get a feel for the decisions that the Fair Work Commission are making. The Fair Work Commission are definitely going to produce decision alerts. So once cases start coming in, we'll get to see decision alerts. They'll also produce quarterly reports. So we'll very quickly be able to see what action they're taking, or whether there's some themes in what the Fair Work Commission are doing. But again, Justice Ross could not say enough about prevention and the fact that they don't want this to be monetary, go away money to hide it under or sweep it under the carpet. So I'll hand over if you'd like to type in any questions, and I will ask those. So I've got some coming through here. Wait a second. Okay, so sorry, someone's just come with a question and then said I've actually answered that one. So is there any more questions that people would like to ask for me to respond to the group? No? If not, please feel free to attend or register the webinars that I'm conducting early next year. If you believe that this information may be of benefit to some of your contacts or to your management team, or the webinar is being recorded and can be made available. But we can also assist you if you are wanting some training conducted or you're needing assistance with anything. Please don't hesitate to give me a call or drop me an email. Again, I really want to commend everyone for taking the time out this morning. It looks like we're going to be able to wrap up a bit earlier, so you can go and get stuck into your work. But really commend you on taking the time, and all the very best for a wonderful, safe Christmas. And we look forward to talking to you in the new year. Thank you very much, everyone.